Hello everyone, welcome to our channel Beyond the Briefcase. We will be discussing about a very important criminal topic, that is criminal conspiracy. Previously, the offense of criminal conspiracy was defined under section 120A of Indian Penal Code, but now it has been given under BNS, that is Bharatiya Nagrik Sanhita 2023 under section 61 subsection 1. So basically, under section 61 subsection 1, criminal conspiracy is an act when two or more persons agree to do an illegal act or an act which is not illegal by an illegal means. So here the term agree is very important. Agree here means that they must agree in this same sense. It basically refers to the idea of consensus ad idem. It is a maxim. It is a maxim which has the literal meaning of meeting of the same minds, or meeting of the minds in the same sense or in the same manner. Now, to understand the offense of criminal conspiracy, these two terms, that is illegal act and act which is not illegal by illegal means, is necessary. So, what do you understand by illegal act? Illegal act is an act which is done for an illegal purpose. Illegal purpose may be defined as a purpose that is done with malified intention, done for illegal purpose, not good for public, and also that the act is forbidden by law. That is, it should not be allowed by the law. Then the next is act which is not illegal by illegal means. It basically means that the act is not illegal itself, but the act should be done by illegal means. So it is not necessary that the act is illegal, but the means to reach the end of that act must be illegal. So this section also provides a proviso to the main general condition. So it states that no agreement except the agreement to commit an offense, that is, the agreement should be made to commit an offense, shall amount to criminal conspiracy unless an act is done in pursuance of that agreement. It basically, in simple words, means that no agreement other than the agreement to commit an offense shall amount to criminal conspiracy unless in the other agreement an act is done in pursuance of the agreement. So, to basically understand the concept of criminal conspiracy, these two elements are very necessary. That is, in this offense, two or more persons are required, because a person itself cannot conspire. In the case of Haradhan Chakrabarti versus Union of India, it was laid down that two or more persons must be parties to an agreement and one person alone can never be held guilty. So, it is essential to note down that one person cannot be held guilty for the offense of criminal conspiracy, and minimum of two and maximum it can be any number of persons to constitute them guilty under this offense. So the second element which is necessary for the offense of criminal conspiracy is agreement. It is the gist of offense. That is, without an agreement, the offense of criminal conspiracy cannot be constituted. And the agreement must fulfill all the conditions as laid down in the Contract Act. So in the case of Chaman Lal versus State of Punjab 2009, it was held that the gist of offence is the bare engagement and association to break the law, whether any act be done in pursuance thereof by the conspirators or not. So in this case, meeting of the minds is necessary. So these two elements, that is two or more persons and an agreement, must be there to fulfill the offense of criminal conspiracy. It is very important to note down that in the absence of agreement, That is, when there is no agreement, a mere thought to commit an offense does not constitute the offense of criminal conspiracy. Moving on further, one more thing is very important to understand the offense of criminal conspiracy, and that is mutual agency. It basically means that every conspirator must be liable for all the acts that is done by any conspirator in the pursuance of agreement. That is, every party to the offense. Every party to the offense must be liable for the acts done by any other person in that agreement. Go. So it basically means that the person does not need to be present in the actus reus. That is, in the act itself. But if he is present in the mens rea, that is, intention to commit an illegal act, then he must be liable for the offense. So, moving further, there is a case. The case of state of Maharashtra and others versus Somnath Thapa and others. In this case, it was held that the knowledge of object is necessary. Knowledge of object is necessary. That is, every conspirator must be aware of the object of agreement. For the offense of criminal conspiracy, the punishment is given under section 61, subsection 2 of the BNS. The first part says that whoever is a party to the offense of criminal conspiracy and he commits an offense which is punishable with death or imprisonment for life or rigorous imprisonment for 2 years or more, then he shall be punished in the same manner as he has abetted such offense. In simple words, we can say that any party to the offense of criminal conspiracy, if he commits an act which is punishable with death or imprisonment for life or rigorous imprisonment for 2 years or more, then he shall be punished in the same manner as if he has abetted such offense. So it basically means that the punishment should be the same as for the offense of abatement. Basically, the second part states that whoever is a party to criminal conspiracy for any offense other than the offense that has been mentioned above, that is in the first part, he shall be punishable for imprisonment up to 6 months or with fine or both. So I hope you have understood the concept of criminal conspiracy under BNS 2023. Thank you for watching the video and I hope you have liked the video.